Can your children be interviewed by the district attorney during a SAIN interview by DCF during a DCF investigation in Massachusetts? The answer is yes and no. It depends on who has custody. If you as the parent have not lost custody, you still have custody of your child, DCF as well as the district attorney have to ask your permission to allow your child to be interviewed. Now there's a caveat here. Often I've seen DCF basically either imply or infer that if you don't do it, they're going to seek legal action and remove your child. That's the wrong way to go about things. So as soon as you hear district attorney, you got to think criminal charges, possible jail time of somebody, somewhere, somehow. And you want to make certain your children are protected as well as you and any other person involved with the case, their legal rights. So you're going to want to immediately get counsel on board, a lawyer, to represent you and your children, to protect their rights. DCF and the district attorney, if DCF has custody, they don't have to ask anybody. They can take your child to the SAIN interview and have that child interviewed without the permission of the parents. And that's a scary scenario. And there's been times in my career where DCF has taken custody for that sole reason, where the parents have refused to allow for the SAIN, and then DCF takes custody and they have the child interviewed without the parents' permission, which is the bad way to go about it, but it's done. So you must understand, you're walking a tenuous line here. You're in a very tenuous position where the DA as well as DCF wants your child to be interviewed at what's called the SAIN interview, Sexual Abuse Interview Network. And you're not sure whether it's in the child's best interest. And how do we determine whether it's in the child's best interest? You absolutely positively should take your child to a therapist, a professional, a trained professional, an expert in the field of child welfare that can speak to your child, understand your child, understand how your child's feeling, but more importantly, also feel the child out as to the child's competency, the child's ability to make a good presentation and be a good witness, the ability of the child who may be ridden with anxiety, as you may be also as a parent, the ability of that child to be able to testify because of his anxiety. You do not want to put the child in further harm's way. Recently I had a case where a child was beyond anxious and DCF wanted to take her to a SAIN interview to have her interviewed. And that just would have been a disaster, as this child was anxious enough. And taking the child to a child welfare said it was not in the child's best interest. It's not saying the interview will not take place, it's just that this time, right here, right now, there will be no interview. And then later on down the road, the anxiety subsides, then you can do the interview. But you want to make sure that you protect your child. Again, your child is not the DA or DCF, the court, the judge, the DCF attorney, or any attorney represent you, their child. Your child is your child. Again, the U.S. Constitution says, we the people, not we the adults. You must protect your children at all costs, at all turns of the corner, and pivot to make sure that when you're doing something, it's because it truly is and has been and always will be in your child's best interest.